Hello, this is Brian Rowe for NIIP, Episode 6, where we're going to talk about whether chess moves can be copyrighted. To give you a little bit of background, about 2 weeks ago, the World Chess Championship happened. This was between Topalov, the challenger, and Anand, the reigning world champion. This was an amazingly exciting chess match. I mean, the first game, Topalov basically crushed Anand right out of the opening with a sacrifice before Viswanathan really knew what was going on, and the rest of the match goes back and forth from there. An incredibly interesting series of 12 games. Now, why is this being covered on a copyright legal video cast, you might ask? Well, the Bulgarian Chess Federation, who in their infinite wisdom to try to make some money off of the event, apparently hired a bunch of lawyers and no one to do decent web design or PR. I ranted about this on my web design personal blog. The site where they broadcast the games was annoying. It had this horrible flash icon at the beginning and you couldn't find things on the site. Well, another chess site, ChessBase, took all of those games, each of the individual moves, and played them out on their servers, allowing people to watch them externally, and then did day-by-day analysis of each of the games, hiring international masters and grandmasters to make commentary on each game, explaining them in plain English for chess patzers like myself. It was extremely good coverage. In my original video about this, I actually recommend that people go to the ChessBase website to follow along for the World Championship instead of going to the horrible Bulgarian chess website. The Bulgarian Federation's website also had this really obnoxious disclaimer at the bottom of the page that basically said, don't redistribute anything that you see here unless you get a specific permission from us. And I emailed them asking for permission at the very outset of this final chess match, and I didn't hear anything back. Now, it might have been because I told them to hire some Gen Y people instead of lawyers and that they don't understand social media, but I did specifically ask for permission, and I didn't even get any information about it back from them. So, what happened here? ChessBase basically took something, a fact that's free, those moves, available online, and packaged it in a way that it was much more useful to the end user. And the Bulgarian Chess Federation has decided to file a lawsuit in the EU, claiming that there's a bunch of unfair competition or copyright-type claims involved. I was really confused about the copyright at first. I mean, chess moves are pretty much facts about what happened, and it's very, very difficult to copyright facts in the US. In the EU, it's a little bit easier because the standard for creativity is lower, but usually it doesn't work. When I finally got a hold of one of the complaint, which was in German, so I've got kind of a poor Google translation of the German, it's not actually a copyright suit. First thing, they're looking at that disclaimer that's on the bottom saying, oh, you can't take anything from this website and reuse it anywhere else, and saying you're blatantly violating this contract, which happens a lot in intellectual property. What happens is somebody puts the intellectual property, the copyright on something, and then also backs it up with this contract. These contracts are often contracts of adhesion. There's no negotiation involved. They're a little bit ridiculous when it comes to them being extremely one-sided. They don't look like a traditional contract where you and I would have sat down and discussed what we want out of a contract. They basically give all rights to one party and none to the other. Often these contracts aren't enforceable, but we're looking at possibly enforcing it here. Second thing is there's a series of other intellectual property rights in the EU that we don't have in the US. One of those is around live transmissions. And as far as I can tell, the Bulgarian Chess Federation is arguing that what happened in this case is that ChessBase basically took this live transmission of chess moves and automatically retransmitted it on their servers. So they're claiming this retransmission intellectual property right that we don't have in the US. It's very special in the EU. I'm not sure that this even qualifies as a full transmission because they weren't taking any of the commentary, any of the photos, anything else that was with it. They were merely taking a small fact and putting that onto another server automatically. The way that the claim is written, it also appears that even if the Bulgarian Chess Federation wins at some case, someone could just do this or do it manually to get around this automatic retransmission rule. This looks like a very weak claim, but maybe the lawyers are hoping that it's cheaper to settle in some way than fight the claim. Second thing is there's this sui generis or database rights in the EU that are talked about in regards to this case, that somehow these particular facts could be covered by a database right. Database rights exist in the EU. They do not exist in the US. They are related to kind of the collection, arrangement, and grouping of a bunch of facts. I'm not sure how you would play these moves in a different way or direction, although I'm not that familiar with these rights in the EU. The important thing here is that this type of protection, or what I would call anti-innovation rules, prevent other people from taking basic facts and using them in a much more useful way to the public. Now, if this same case was in the United States, it would get tossed extremely quickly. There's a case a few years back where the NBA sued Motorola, I believe it was, with regards to NBA sports scores. Motorola was taking those sports scores and retransmitting them to individuals on the cell phone instantaneously as they were happening. NBA actually won in the lower court, but when it got appealed up to the Second Circuit, they tossed it entirely. Said it didn't fall into this doctrine called hot news. Probably end up talking about hot news on another cast because it's a horrible can of worms in itself. But basically, these are facts. There's so little around them. It's up for the actual contact, the actual numbers themselves, that they don't gain any protection here in the US. Now, this lawsuit and what's going on in this case is not unique to the EU by any matters. I mean, we saw the NBA case in the US, but this is the exact same thing that's happening last week with New York Times shutting down an iPhone app for accessing its RSS. It's real simple syndication, the RSS feed. This iPhone app was taking the pieces of content that are on the New York Times site, freely available, and putting it up in a way so that individuals on their iPads or iPods could access them instantaneously, or iPhones. New York Times tried to say, oh, we got this contract on our website and you can't do this because you're commercially profiting. A day later, they noticed that, wait, we've actually had people review this. It seems like a really good thing. And they got rid of their claim to have it taken down and put everything back up. But this shows how confused old media is over how the new media landscape works. If you want to compete, and if you want to do a good job with intellectual property in the 21st century, you need to enable sharing, get credit for yourself, and find other ways to monetize. You're not going to win fighting the crowd, which is going to find better ways to share things and ways to add on content. Stop hiring lawyers and start hiring Gen Y individuals who understand how information flows in a digital economy. This has been Brian Rowe for New NIIP. Remember, your rights, your First Amendment fair use rights are your own. Use them or lose them.